May 28, 2022, Corporal Michael Pritch of the Little Egg Harbor Police Department in Ocean County, New Jersey, stopped his vehicle and approached a young man who was walking on the side of the road after the man, who we will refer to as Mr. Walker, gave the finger to Corporal Pritch. The interaction was captured on Corporal Pritch's body-worn camera.
Why you giving me the finger?
What?
What's your problem?
What?
Why you giving me the finger?
I'm walking away.
Huh?
Am I free to go?
Why you giving me the finger?
Am I free to go?
No. Come
For
here.
what reason?
Why you giving me the finger? What's your problem?
Am I free to go?
No.
What, do you have a problem?
No.
You have a problem?
No.
You don't have a problem, then I can leave.
Why you giving me the finger when you're walking? Huh? Come here. Get over here.
What?
Get over here.
Is that a lawful order?
Yeah.
For what reason?
Because you're giving me the finger.
That's legal.
No, it isn't.
Says who?
Says it all.
Pull up the law.
Huh?
Pull up the law.
What's your name?
What's the law?
What's your
What's
name?
the law?
What's your name? How old are you?
Corporal Pritch claims that it is illegal to give him the finger, and therefore he can lawfully detain Mr. Walker for doing so. As we have discussed before on ATA, the Supreme Court held in the 1971 case of Cohen versus California that, quote, absent a more particularized and compelling reason for its actions, the state may not, consistently with the First and 14th Amendments, make the simple public display here involved of this single four-letter expletive a criminal offense. Likewise, as the Supreme Court explained in the 1989 case of Texas versus Johnson, while, quote, the First Amendment literally forbids the abridgment only of speech, its protection does not end at the spoken or written word. Conduct may be sufficiently imbued with elements of communication to fall within the scope of the First and 14th Amendments. The court also stated that, quote, in deciding whether particular conduct possesses sufficient communicative elements to bring the First Amendment into play, we have asked whether an intent to convey a particularized message was present, and whether the likelihood was great that the message would be understood by those who viewed it. Although the Supreme Court has not ruled specifically as to whether raising a middle finger constitutes protected speech, the gesture nearly inarguably satisfies the test for expressive conduct outlined in Texas versus Johnson, and courts that have reviewed the issue have generally concluded that it is protected speech. In the 2006 case of Corey versus Nason, the U.S. District Court in the Western District of Pennsylvania, which is in the same federal circuit as New Jersey, concluded that, quote, the weight of federal authority establishes that directing the middle finger at a police officer is protected expression under the First Amendment, absent some particularized showing that the gesture in the specific factual context constitutes fighting words or is otherwise illegal. According to Section 2C 33-2, quote, a person is guilty of a petty disorderly persons offense if, in a public place and with purpose to offend the sensibilities of a hearer or in reckless disregard of the probability of so doing, he addresses unreasonably loud and offensively coarse or abusive language, given the circumstances of the person present and the setting of the utterance, to any person present. In the 2022 case of Morales versus Maxwell, the U.S. District Court for the District of New Jersey held that an individual could not be convicted of disorderly conduct under this statute for shouting profanities at a police officer because, quote, under long-standing precedent, the statute violates the First Amendment when applied to language short of that which would incite the hearer to immediate violence, and the profanities he shouted at the officer, quote, by themselves do not constitute fighting words that would provide probable cause for arrest under the disorderly person statute. Given this precedent, it is highly likely that a court reviewing this situation would determine that Mr. Walker's use of the middle finger was protected speech, and that he could not be arrested under the disorderly conduct statute for directing the gesture at Corporal Pritch.
I appreciate it. Have a good one.
Whatever. What?
You heard me.
Come here.
I'm afraid of you.
Come here. Get over here.
What?
Get over here.
I'm not doing anything illegal.
Yeah, you are. You just cursed me off.
That's not a crime.
Yes, it is.
Says who?
Says me.
Says who?
Turn around. Come on.
Bro, that is not a crime.
Yes, it is.
No, it's not.
Why are you cursing me?
It's not a crime.
What's your name?
It's not a crime.
What's your name?
Help! Help!
No help.
Help! Help!
Yo.
Help!
Corporal Pritch grabs Mr. Walker and holds him with his hands behind his back. When Mr. Walker starts screaming for help, Corporal Pritch turns off his body-worn camera and does not turn it back on until backup arrives. Under Section 40A 14-118.3 of the New Jersey statutes, every uniformed law enforcement officer is required to wear a body-worn camera that electronically records audio and video while acting in the performance of their official duties, with limited exceptions. Additionally, Section 40A 14-118.5 states that, quote, the video and audio recording functions of a body-worn camera shall be activated whenever the officer is responding to a call for service, or at the initiation of any other law enforcement or investigative encounter between an officer and a member of the public, and that, quote, the body-worn camera shall remain activated until the encounter has fully concluded and the officer leaves the scene. Likewise, the statute only allows for the deactivation of a body-worn camera during an encounter, quote, when a civilian conversing with the officer requests that the device be deactivated where it reasonably appears that the person will not provide information or otherwise cooperate with the officer unless that request is respected, when a person other than an arrestee is seeking emergency medical services for themselves or another person and requests that the device be deactivated, while the officer is participating in a discussion pertaining to criminal investigation strategy and planning, or when specifically authorized to do so by an assistant prosecutor or an assistant or deputy attorney general for good and sufficient cause. These legal requirements are expanded upon in the body-worn camera policy issued by the Office of the Attorney General for the state of New Jersey, and it is clear that Corporal Pritch's actions in turning off the body-worn camera violated both state law and the Attorney General's policy.
I'm under arrest right now because I was cursing at him. And he said,
you're being detained because you're acting strange.
what? That's not legal.
It is legal. He's allowed to
Who is
detain
this
you
kid?
until he performs his
So what am I
investigation.
doing though? What am I doing that made him detain me? What legal
Every
right?
time I rode by him twice, he shot me the finger. So I turned around and said, well, you're
Is that a crime?
No problem.
Hold
Then
on
he
a
tells
second.
me
That's not a
This is
crime.
causing public disturbance.
And then he
That's
tells
not,
me to
no, that's not a
to
crime.
F off, pig.
Yeah, off, big. That's not a crime. That's not a crime. He's looking at you because he's like, what the fuck you want me to do? Because it's not a crime. I know my rights.
Who are you?
I don't have to say any of that.
You do if you're being detained.
For what reason?
What is your
legal
name?
reason am I being detained for?
Where are you coming from and where are you
What
going?
legal reason am I being detained for? I need to know that. Legally, I need to know that.
Patrolman Michael James Lamontagne arrives on the scene and informs Mr. Walker that he is required to identify himself because he is being detained, even though he cannot provide a legal justification for the detention. However, New Jersey does not have a stop and identify statute that specifically requires Mr. Walker to identify himself, and courts have determined that New Jersey's obstruction statute cannot be applied to individuals who refuse to identify themselves to police officers when they are not suspected of committing a motor vehicle offense. Under Section 2C 29-1 of the New Jersey Code, quote, a person commits an offense if he purposely obstructs, impairs, or perverts the administration of law or other governmental function, or prevents or attempts to prevent a public servant from lawfully performing an official function by means of flight, intimidation, force, violence, or physical interference or obstacle, or by means of any independently unlawful act. Although the statute does not require that an individual physically obstruct an officer to be convicted of obstruction, in the 2020 case of Bryant versus Camden County Police Department, the Superior Court of the New Jersey Appellate Division held that an individual, quote, had the right to refuse to turn over his identification when an officer demanded it during a police investigation that was not initiated on the belief that the individual had violated a motor vehicle law, and that he could not be arrested for refusing to identify himself because he, quote, committed no unlawful act to impede the investigation. Therefore, a court would very likely determine that Patrolman Lamontagne was incorrect in his assertion that Mr. Walker was required to identify himself.
Why are you
Shooting me the finger.
Why are you
Is that illegal?
Why are
Cursing
you
at
flipping the bird? Yes, it is. When you are cursing in public, you are causing a public disturbance. You're being a nuisance to the public.
In what way? When he was driving past? Well, I'd like to see you guys prove it in court.
It's called causing a public disturbance.
I know the
by
law.
being a nuisance.
I know the law.
I'm not saying you're being charged with anything. At that
I'm
point,
just
he's
figuring out
detaining
what's wrong with you.
to make
What's
sure that
going
there
on?
is nothing
Make
wrong.
sure you're okay.
What
Make sure that
reason,
you're okay.
What reason does he need to detain me?
He thought maybe he thought you were signaling him down. Were
I
you
was.
signaling to him?
No,
Listen, I was
no,
just-
you knew very well that I wasn't signaling to you, right? I wasn't signaling
Well,
to you.
you bring attention to yourself.
That's not signaling.
You're acting strange. I'm making sure you're okay.
Dude, that's so funny. Like, you're not here for my safety. You're not trying to protect
How
me.
do you know?
You're walking
may
on the
be-
side of the road and you're cursing and you're flipping the bird.
Once at him. I gave him the finger once. That
you know
will
him?
not hold up.
Do you know him? Do you know him?
It's not your business. I
It is
plead the
my
fifth.
business.
I plead the fifth then.
It's
What's
in
the First
public
Amendment
law.
for?
Okay. First Amendment is for your freedom of speech. Okay.
Okay.
What does that have to do with
Was I
using
making a call to
gestures?
action? Am I calling for an action to be done against you?
Do
No.
you understand
You're
that
bringing
it is?
attention to
Listen,
yourself and
listen,
get
listen, listen.
That's not legal.
It's It's behavior that's out of the ordinary. Clearly, if you stopped all the way back there, I'm assuming you guys were back there and you just
We
continued
were
to
back
walk.
a bit further
And you
back.
just continued to walk.
I wasn't running, I was walking.
Once he
So
gives an order
let's
for you
be
to
honest here.
stop, you're supposed to stop.
I did stop when he originally said it, but I was asking, is it illegal? Is it a lawful order?
and he took off.
Yeah, because I kept walking because you weren't pursuing at the first. You
All
only
right.
started pursuing because
So
I said "F you, pig." That's when
listen.
you got a little upset.
Look, we're here at this point now, okay? You've brought the attention to yourself, you've
Yep.
caused the public alarm.
Well,
What
I'd like
we
to
are
see
doing-
you legally
so
hold
now
that
what we
in
are
court,
doing,
because-
I'm not charging you with anything, so I
Well,
don't
I
legally
would-
need to hold anything in court.
Well, I want to know from your
I
perspective. What was
pulled
I
up onto the
what
scene,
did
so
you
you
do?
tell me what you were
To
doing.
bring you attention.
I plead the fifth. You idiot. How long have you been a cop? 6?
Longer than you.
Listen,
Longer than you, I'm not a cop.
I don't understand what the point of this is.
I'm walking. That's what I'm doing.
Okay.
It's the Fourth Amendment to be allowed to walk without seizures or anything like that.
You
Which
sure?
is, yes.
Are you sure that's the Fourth Amendment? You
You
sure?
want to bet money on it?
You sure that's what the Fourth Amendment? It gives you the right to walk without seizure. What's going to be seizured while you're walking?
My body, my person, idiot. You were about to.
Listen.
He said I was going to be under arrest. He
You
said it.
said you were
I said
detained.
stop.
You
No,
said you were
we're
detained.
gonna be arrested.
So now what
Yeah,
happens?
so
now what happens?
he just admitted that
now
he was
what
going
happens
to
is when
arrest
he
me.
gives you a lawful order to stop, and you do
It
not
wasn't a
stop.
lawful order, though.
And you do not stop.
It legally was not a
and
lawful
you
order.
do not stop, then that becomes a criminal offense, and then yes, you can be put under
But
arrest.
it's not a lawful order. Then I take it to court, and then he'd get sued, and I get
Maybe.
punitive damages. I'd be rich. Is that what you want?
That
You don't know the law,
may be
buddy.
what happens
You don't know
if
the
you
law.
think that that's going to happen.
Patrolman Lamong Tang claims that the Fourth Amendment was not implicated in this interaction because no seizure occurred and Mr. Walker was not placed under arrest. However, as the Supreme Court explained in the infamous 1968 case of Terry versus Ohio, quote, "The Fourth Amendment provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. This inestimable right of personal security belongs as much to the citizen on the streets of our cities as to the homeowner closeted in his study to dispose of his secret affairs. For, as this court has always recognized, no right is held more sacred or is more carefully guarded by the common law than the right of every individual to the possession and control of his own person, free from all restraint or interference of others, unless by clear and unquestionable authority of law." Based on this principle, the court determined that, quote, "It is quite plain that the Fourth Amendment governs seizures of the person which do not eventuate in a trip to the station house and prosecution for crime, arrests in traditional terminology. It must be recognized that whenever a police officer accosts an individual and restrains his freedom to walk away, he has seized that person." Building on this decision, the Supreme Court held in the 1980 case of United States versus Mendenhall that, quote, "A person has been seized within the meaning of the Fourth Amendment only if, in view of all of the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave." Examples of circumstances that might indicate a seizure, even where the person did not attempt to leave, would be the threatening presence of several officers, the display of a weapon by an officer, some physical touching of the person of the citizen, or the use of language or tone of voice indicating that compliance with the officer's request might be compelled. Additionally, in the 1991 case of California versus Hodari D., the Supreme Court clarified that, quote, "To constitute a seizure of the person, just as to constitute an arrest, the quintessential seizure of the person under Fourth Amendment jurisprudence, there must be either the application of physical force, however slight, or, where that is absent, submission to an officer's show of authority to restrain the subject's liberty." Here, it is undeniable that Mr. Walker was seized when Corporal Pritch initiated physical contact with Mr. Walker to prevent him from leaving. However, it is also highly probable that a court would conclude Mr. Walker was seized for Fourth Amendment purposes when Corporal Pritch first ordered him to stop, and he complied.
It may be what's going to happen. It may not be what happens. Okay.
Okay, I
What may
understand.
happen is
All right, so
is
what
you
are we
may get a
wasting time
normal
for?
jury.
Am I free to go?
What
Am I
may
free to
happen
go?
is you may
Am
get
I
a
free to
normal
go?
jury. No, because at this point
For what reason?
you were detained. Okay, because he told you to stop
Okay.
and you didn't stop.
Okay.
So therefore, you need to identify yourself as a part of the investigation. So what is your name?
Okay, I'm gonna need all of your badge numbers.
I
Most
will
of your
give
badge
you everything
numbers.
written down on a card. What is your
I
name?
can give you.
If you have an ID,
Am I?
that's perfect.
Am I? Okay. I'll take it to court
If you have
because
an
this
ID,
is
that's
still
perfect.
this is still a detainment.
Are you a juvenile?
This is an illegal detainment,
Are
so
you
I
a
can still.
juvenile?
I'm not going to answer that.
You have to answer.
Why?
Because you're being detained.
I said I'll give you my ID, buddy. He's such a pig, bro.
So what does that make you?
Not a pig.
What does
Dude,
that
this
make
is
you for
illegal.
saying?
You'll legally have to prove that I was a nuisance
When
to
you're
the public.
standing-
How will you do that? How will you do that? I just want to hear
Camera
your-
systems. Okay, so when he goes by in the car, okay, and he sees you doing what you're doing,
And what was
that's
I
all gonna
doing?
be there.
And what part of that caused a disturbance. That's what I'm trying to legally understand. I don't understand. Is that a body camera?
That's what it is.
Perfect. Tuckerton doesn't have them. You know that? Tuckerton's been on back order for months.
How do you know?
Because I have a lawsuit against them. That's why. And I wish they'd have body cams. I would love if they had body cams. Take out the bad cops.
It's for all of us.
Right.
It's for all of us. It's for everybody that's involved in the situation. Okay?
Appreciate it.
If you have any problems or anything, and you want to come down, you want to talk to somebody, our supervisors are always there as well. Okay?
Well, I'm going to
And
take
you
a
can do
lawsuit.
that.
So who would I press criminal charges against? For what?
You're gonna have to. You're gonna have to
police
call.
officers.
You're gonna have to call and figure that out with a lawyer. You would have to file a complaint with the courts.
Got it.
Okay, and then you can go from there if you want to see if you can press charges and whatnot if you
Perfect.
violated your rights.
Appreciate it.
Okay.
Stay
All
out
right,
of the
am I
roadway.
free to go?
Don't give us fingers.
Shut the f up.
Stay out of the roadway. Stop causing a public alarm.
Dude, shut the f up. Am I free
Stop
to go?
cursing.
Am I
You're free to go.
Stop cursing. Go.
You're free to go.
After Patrolman Lamontagne informed Mr. Walker that he was free to go, Mr. Walker directed a profanity at both of the officers and walked away without any further incident. Very little information is available about this interaction, and although Mr. Walker informed the officers of his intent to pursue legal action, it is unknown whether he has taken any steps to do so. Overall, Corporal Pritch and Patrolman Lamontagne get an F for acting with total disregard to Mr. Walker's First Amendment and Fourth Amendment rights, detaining him without reasonable suspicion to do so, and blatantly misstating the law multiple times throughout the encounter. The officers repeatedly demonstrated their complete ignorance of some of the most essential legal principles that apply to law enforcement officers by falsely claiming that it was illegal for Mr. Walker to use profanity and display his middle finger, that Mr. Walker was legally required to identify himself, and that their illegal detention of Mr. Walker did not violate the Fourth Amendment, or even implicate it because he was not formally arrested. While both officers could certainly benefit from additional training, it is also crucial to discuss the fact that Corporal Pritch chose to turn off his body camera when Mr. Walker started screaming for help, despite the fact that it clearly violated both state law and policy. Although Mr. Walker did not appear to be injured when Patrolman Lamontagne arrived and the body camera was reactivated, it is immensely troubling that Corporal Pritch intentionally and illegally prevented his interaction with Mr. Walker during this time from being recorded. And this sort of deliberate action demonstrates more than mere ignorance of the law that could potentially be corrected through training. Mr. Walker gets an A-, because although he provided the officers with his identification when he was not legally required to do so, he demonstrated a strong understanding of his constitutional rights, stood up to the officers when they repeatedly misstated the law, and even attempted to educate the officers about the constitutional rights of citizens when they repeatedly revealed their ignorance. While Mr. Walker maintained a hostile demeanor with the officers and used some inflammatory language, he was well within his First Amendment rights to do so, and I would encourage him to follow through on his intentions of filing a lawsuit against these officers for their illegal and unconstitutional actions. I commend Mr. Walker for taking an interest in constitutional rights at such a young age.